RTM meeting on Monday, March 25th. Will the clerk please call the roll?
Steve Cesare. David Fogel. Nancy Lefkowitz. Mr. Fogel, do you have an announcement from District 1?
Yes, we would like to announce and welcome Amy O'Shea, who is taking the place of Keith Barry.
Amy O'Shea. Bill Gerber.
Here.
Aaron Lopez. Eric Newman. Cindy Perham. Heather Dean. Alex Durrell. Matt Jacobs. Sharon Pastilli. Alice Kelly. Phil Pierce.
Here.
Marcy Spolier. Josh Garskoff. Joe Siebert. Ruth Smay. Jay Wolk. Matt Ambrose. Steve Barretts. Hannah Gale. Lisa Havey. Lauren Bove. Mark McDermott. Jill Vergara. Karen Wackerman. Carrie Burcham. Pamela Iacono. Christine Messina. Pete Talman. Brian Farnan. Drew Georgiadis. Doreen Herron. Margaret Horton. Sam Cargill. Michael Hurley. Frank Patisse. Eric Sunman.
Our first selectman has an announcement to make, so I'd like to invite him up to the podium.
Thank you. It's my honor to get up here and read a proclamation. And I'm not going to read the whole thing, but I'll read enough of it so you understand what's going on. The town of Fairfield proudly congratulates Town Clerk Betsy Brown for being awarded the distinct designation of Master Municipal Clerk, MMC. The International Institute of Municipal Clerks grants the MFC designation only to those municipal clerks who complete demanding educational requirements and who have a record of significant contributions to their local government, community, and state. Betsy didn't quite want me to say this, but there's only a few people in the country that have this designation. The IMC's Code of Ethics includes rendering equal service to all, recording that which is true, preserving that entrusted to the town clerk, and constantly striving to improve administration of the town clerk's office through sound management to fill the needs of the community. And Betsy not only epitomizes these principles and ethics, she brings an extraordinary breadth of experience to the elected position of Fairfield Town Clerk in a role she has been proudly serving since 2005. It goes on through a whole list of Betsy's accomplishments. I know she'd be too embarrassed if I read them all to you. However, I will get down to my other favorite part, which is, now therefore, I, Michael C. Tetro, First Selectman of the town of Fairfield, do hereby proclaim Monday, March 25th, 2019, as Elizabeth P. Brown Day throughout the town of Fairfield. Congratulations, Betsy.
Congratulations, Betsy. Now I'll ask you to lead us in the Pledge of Allegiance. Okay, so item 2, to consider and act upon the minutes of the regular meeting held on February 25th, 2019. Is there a motion to approve? Moved by Representative Dean, seconded by Representative Lefkowitz. Is there any discussion on this item? Seeing none, is there any comment from the public on the minutes? Seeing none, all those in favor, please signify by saying aye. Aye. All opposed? Any abstentions? The motion carries. Item 3, to consider and act upon the following resolution as recommended by the Board of Finance. Resolved that the bond resolution entitled a resolution appropriating $1,400,000 for the costs of a tower ladder fire truck with a 100-foot hydraulically operated ladder and ancillary equipment, and authorizing the issuance of bonds to finance such appropriation be and hereby is approved. Is there a motion to approve? Moved by Representative Vergara, seconded by Representative Smay. Is there any discussion on this item? Seeing none, is there any comment from the public? Seeing none, all those in favor, please signify by saying aye. Aye. All opposed? Any abstentions? The motion carries. Item 4, to consider and act upon the following resolution as recommended by the Board of Education. Resolved that in accordance with Connecticut General Statute 10-153B, the collective bargaining agreement between the Board of Education and the Fairfield School Administrators Association, FSAA, for the period of July 1, 2019 through June 30, 2022 is rejected. Is there a motion to approve this resolution? Moved by Representative Dean, seconded by Representative Wackerman. And just to be clear, the motion is to reject the contract, so a vote yes is a vote to reject the contract, which means that it's not a contract. And a vote no is a vote to refuse to reject, which means that the contract would be in effect. So it's essentially an opposite resolution. So with that preface, is there any discussion on this item from the body? Seeing none, is there any comment from the public? Seeing none, we'll come back to the body. And again, a yes vote is a vote in favor of rejection. A no vote is a vote in favor of the contract. All those in favor, please signify by saying aye. All opposed? You guys did great. Any abstentions? Okay, the motion fails unanimously. Item 5, to consider and act upon a report from the Fairfield Historic District Commission concerning the designation of 554 Tungus Hill Road as a historic property. Is there a motion to approve? Moved by Representative Vergara, seconded by Representative Dean. Before we open it up to comment, a letter was submitted by Trinity St. Michael's Episcopal Church to the RTM, and I just want to read that for the members. To the members of the representative town meeting, the parishioners of Trinity St. Michael's Episcopal Church would like to inform the representative town meeting of Fairfield that our congregation is in favor of designating the 1922 structure at 554 Tungus Hill Road as a Fairfield historic property. Thank you for your consideration. Sincerely, Father Raymond Cox, Minnesota priest, and several other people on behalf of the congregation. So I'll now open it up to comment. Is there any comment on this item? Seeing none from the body, is there any comment from the public? Seeing none, all those in favor of accepting the report, all those in favor of the report from the Fairfield Historic District Commission concerning this property, please signify by saying aye. Aye. All opposed? Any abstentions? The motion carries. Item 6, to consider and act upon amendments to the recovery of costs related to properties with breaches of the peace, public disturbances, and disorderly conduct, Section 61-1 of the Town Code of the Town of Fairfield, sponsored by Brian Farnan, District 9, Drew Georgiadis, District 9, and Margaret Horton, District 9. Is there a motion to approve? Moved by Representative Georgiadis, seconded by Representative Bove. Is there any discussion on this item? Representative Vergara. Over there, there's the mic.
Jill Vergara, District 7. I think that the provision in 61-1A3 for changing the 6-month time period to 3 years is too onerous for landlords. I don't see a need to change it longer than 2 years. So I want to make an amendment to change it to a 2-year date. Thank you.
Okay. Is there a second for the motion to amend? Seconded by Representative Iacono. Is there any discussion on the motion to amend the ordinance to change the years from 3 years to 2 years? Representative Georgiadis.
Drew Georgiadis, District 9. This is an amendment to an existing ordinance. I was asked specifically by the president of the Fairfield Beach Residents Association and the police chief to change the date, the length of time to the 3-year period, mostly for administrative reasons. There are a lot of requirements as far as sending letters and all this administrative information and requirements. So I support the 3 years. I oppose the amendment. The 3 years is what the police chief says will be allow for less of a burden on the police department. And so I support the movement from the 6 months to the 3 years. Thank you.
Is there further discussion on this item? Representative Farnan.
Brian Farnan, District 9. I also I'm against this amendment. Don't want to echo anything Drew mentioned. I would just add on top of that, I have full support in our police department to show a certain level of discretion and reasonableness in the implementation of this revised ordinance. One thing I would like to offer, and I'll do as a separate amendment after we have a vote on this, will be to add a cap of potential charges for $3,000. Such cap would potentially minimize any potential overreach by the police department, and hopefully that in some ways will alleviate some of your concerns in the amendment that you're proposing. Thank you.
Is there further discussion on the proposed amendment to the amended ordinance? Representative Hurley.
Michael Hurley, RTM District 10. Mr. Moderator, I think these will be, particularly what Mr. Representative Farnan added, material changes to the ordinance, and I ask that you consider that this be sent back to committee for further review and discussion and public hearings. Thank you.
Okay, so the only item before the body right now is a motion to amend the number of years from 3 to 2. That's the item before the body right now. We'll take up amendments and their effect on the ordinance as they come. So,
I understand and I respect that, but as the moderator of the body, when you have a co-sponsor of the ordinance saying that he's going to propose another amendment which is going to institute a cap, I think that needs to be taken into consideration. I think it should be taken into consideration now. You can rule differently, you're the moderator, but that's my opinion.
so that is not a motion that's before the body. The only motion that's before the body is to reduce the years from 3 to 2. So we'll take up Representative Farnan's amendment after this amendment. Representative Selectman Bateson.
Hi, Ed Bateson, North Street in Fairfield. In the interest of full disclosure, I am a landlord at the beach. I apologize for chiming in at the last minute. We've been busy the past couple of meetings with budget at the selectman level. I support Representative Reguera's amendment. I will offer this as a landlord. I understand where we're going with this ordinance. I've always been supportive of this type of ordinance because it helps me as a landlord enforce. I see it as a good thing. This one, 6 months, I agree, was a little too short. It wasn't even a full academic year. I would have been happy with a year. 3 years, I do think is a little too onerous for the simple fact that I only rent out to seniors on my property. So if something happens, I have a bad house, something happens, those kids move out, I have that one incident. That one incident will now carry over into the next academic year, possibly into the second academic year. My concern is next September, I'll have a new group of students move in. I have to sit down, read them the Riot Act on Labor Day weekend, say this is what you can and can't do, here's our mutual expectations and so forth. And oh, by the way, you are already at strike 3. Because last year I had a problem in this house and now that carries over. I know what my responsibilities are as a landlord and what the ordinance reads, and I can enforce that. My problem is I feel bad enforcing that for the simple fact that these new kids are paying for an old sin. That causes me concern. I don't think that that's equitable on the new kids. I will do it if that's the law, but it's hard for me to sell it. It just is, guys. I just feel that 3 years is too long. In the interest of moving it forward, though, 2 years, I could live with that. Thank you.
Further discussion on Representative Vergara's proposed amendment. Representative Horton.
Margaret Horton, District 9. First, I want to make sure that we're keeping in mind that this ordinance exists. I feel like sometimes that's getting a little bit lost in the discussion, that we are talking about amendments to an existing ordinance. And Mr. Moderator, through you, I was wondering if we could ask Chief Liddy to speak on why the police department feels that, these amendments and particularly this length of time will be helpful to the police in their work.
Certainly, Chief Liddy.
Thank you very much. Yes, I'm reminded that the ordinance exists, and the goal of the ordinance has only been to get the missing component, which has been the landlords, as part of the discussion. And to Selectman Bates's point, well taken, and you are not in that category of a missing landlord, but there are many that are missing in the discussion. We're not trying to raise revenue, but there are administrative things behind the scenes that take place that my office has to produce, certified mailings and things of that nature. The 3 years will aid us in reducing some of the administrative costs associated with this and the time that we spend doing it. By no means do I think it should be a precluder for this important ordinance, but 3 years would be very helpful. Thank you.
Thank you. Is there further discussion on this item? The amendment? To the amendments? Seeing no discussion from the body, is there any comment from the public on the proposed amendment to reduce the years from 3 to 2? Seeing no comment from the public, we'll come back to the body and we'll do a roll call vote on the proposed amendment to reduce the years from 3 to 2 in which section of the, Representative Vergara, which section of the ordinance? A3. Section A3 of the ordinance.
Steve Chesery? Yes. Dave Fogel?
Yes.
Nancy Lefkowitz? No. Amy O'Shea? Yes. Bill Gerber?
No.
Aaron Lopez? No. Cindy Perham? No. Heather Dean? No. Alex Durrell? Yes. Sharon Pastilli? No. Bill Pierce?
No.
Marcy Follier? No. Josh Garskopf?
No.
Joe Siebert? No. Ruth May? No. Jay Wolk? No. Steve Barrett?
No.
Hannah Gale? Yes. Lisa Havey? No. Lauren Bovee? No. Mark McDermott?
No.
Jill Vergara? Yes. Karen Wackerman? Yes. Carrie Burcham? Yes. Pam Iacono? Yes. Christine Messina? Yes. Peter Tallman?
Yes.
Brian Farnan?
No.
Drew Georgiadis? No. Doreen Herron? Margaret Horton? No. Sam Cargill?
Yes.
Michael Hurley?
Abstain.
Eric Sunman?
Yes.
Alex Durrell?
Yes.
Motion fails 13-19-1.
So the motion fails 13-19-1. So the item is still before the body, the amendments without that proposed amendment. Is there any further discussion on the item before the body? Representative Farnan.
Brian Farnan, District 9. I'd like to propose a friendly amendment to Section A4. So it would read as such that I'll read the existing language and then I'll pause to tell you what the new language is. Prior to initiating any claim to collect any such debt, the town shall provide such owner a bill itemizing the charges and afford at least 60 days to pay the bill. That's the existing language, and I would like to add after that in A4 a comma and state, provided that no such charge shall exceed $3,000, period.
Is there a second for the motion? Seconded by Representative Georgiadis. Okay, so is there any discussion on, so Representative Farnan, just so I'm clear on your amendment, the only words that are being inserted are, there's a comma and then it's provided that no such charge, I can't read my writing, sorry, shall exceed $3,000. That's the proposed amendment?
Correct, provided that
Okay.
no such charge shall exceed $3,000, period.
So is there any discussion on the proposed amendment, Representative Garskov?
Hi, Josh Garskoff, District 5. Just a question for the proposer. Is this intended to be a $3,000 cap? I think you said that earlier, but I'm not sure that that's what I'm hearing this as necessarily. Is there maybe language to clarify that? Do you understand my question? I'm worried it could be individual charges of 3,000 could multiply.
Yes, this is meant to be a cap. Hopefully, this conversation and the minutes from this meeting could be used as legislative history. But I do think I would like to keep it simple. In the provided no such charge shall exceed $3,000, and the fact that earlier it does speak to such charge, and it's that language that is being proposed to be added is consistent with it, and the intent would be to be a cap on the charge that could be assessed to such landlord. I would think it would be for the incidents that would lead to the charge itself. So if there were, let's say the police were to come 3 times to a landlord's place, the police department were to assess a charge of $3,000 that was itemized and sent, and then that happened all in the first 14 months, and then if there was an additional separate 3 issues, that those in their totality, you could still have 2 separate charges that would be 3,000 and 3,000. I'm open to other suggestions, but I think the likelihood of that happening is very small. And at the end of the day, I do have confidence in our police department to, administer this in a very reasonable and fair manner. And the fact that over the 18-year history of this existing ordinance, I am not aware of it being used. So I don't expect that this is now, upon adoption, now going to be an abused ordinance.
Thank you. So I think what I'm hearing you say is that there could be a $3,000 maximum charge one time, and then another time it could happen again, right?
For 3 incidents, so there's no one such incident, right? So
to understand the ordinance, one incident does not cause rise to the police department being able to assess these charges. But if all the other conditions of this ordinance are met for the charge to be applied, and those charges are applied to those incidents, which is consistent with this ordinance, you could see that after that period, there could be another 3 incidents that if they were consistent with this ordinance, they could be applied. But you could be talking, that would be in the most outrageous of scenarios where you would have, 2 to 3 or 3 incidents going through a formal process, and then another 3 incidents going through a formal process, which I think is extremely unlikely.
Just want to make sure I understood. Thank you.
Is there further discussion on Representative Farnan's proposed amendment? Representative Gerber.
Through you, Mr. Moderator, to Representative Farnan, I may have misread the ordinance, but I thought if you have 3, then the 4th, 5th, 6th would all be charged. Am I correct? It's not 3, then another 3, then another 3. I didn't think. So it would be 3 incidents, then the 4th 3,000, then the 5th 3,000, then the 6th 3,000. Am I correct, Representative Farnan?
a busy day. Sorry, I read it earlier today, but have not looked back at it since then. A charge against such owner of such property, charge constant due. It's my understanding of the ordinance, and others are welcome to chime in on their interpretation, but you would be charged upon the third, you could be charged for all the actions that were previously occurred, correct? Would you agree with that assessment? Is that consistent? Okay. So you would see after that third item that those charges for the first, second, and third would then be assessed to that landlord, correct? And that would occur through a formal process with a bill being charged. So that I would say, in maximum, those three items could not exceed $3,000.
But a fourth within the same period of time, how would that be assessed? And a fifth?
It would be, and I'm open to this, but those would be open to that, an additional $3,000 cap. If people think that's onerous, I would be welcome to additional language to massage it further, but I think the likelihood of that occurring is very small.
Well, if there's if there's a really trouble situation, then they could be every weekend, sort of. And the idea would be that there'd be a 3,000 cap at the third, but then there could be another 3,000 cap in the fourth and the fifth, because if it's that could conceivably happen in a really bad situation.
Open to further discussion. One potential solution is to do $3,000 in a 3-year period, or in such 3-year period, if that makes people more comfortable. I think the dollar amounts can be much smaller than $3,000. So I'm happy to, if this helps alleviate some concerns of the overreach to landlords, we could say, provided that no such charge shall exceed $3,000 during such 3-year period.
Is that a new motion?
No, I'm actually opposed to your motion.
Get down.
I'm opposed to your motion because I think it's unnecessary, and I would ask Chief Liddy. If we've never had amounts, totaling more than 3,000, which I believe this is just administrative time, I think this is sort of an unnecessary motion, and certainly wouldn't want to do this until we saw that overreach. We can go back and adjust it if we did, but it's unlikely that we will. So it almost seems unnecessary to me.
Since I'm here, I'm going to cut back in line. I'd like to make a second friendly amendment, hopefully to win you over, provided that no such charge shall exceed $3,000 within such 3-year period.
Okay, so I don't think you can amend an amendment.
So I will withdraw my first amendment. And since I'm here, I would like to make a amendment to this wonderful ordinance in section A4, can I withdraw since it was seconded, or was it seconded? Yes, it was seconded. Can I still withdraw it?
The second, as I hear, has also been withdrawn. So
perfect.
You're in good company.
All right. Thank you. I thank you for your Robert Rules of Order knowledge. So I would now like to make a new amendment in section A4 to read, and I'll read the last sentence and then I'll pause, and where the new addition would be. Prior to initiating an action to collect any such debt, the town should provide such owner a bill itemizing the charges and afford at least 60 days to pay the bill, new language, comma, provided that no such charge shall exceed $3,000 in such 3-year period. You don't like it? No, I have a question. Oh, okay. That was a motion.
One second. So the addition is provided that no such charge shall exceed $3,000. What was the last part that you added? During, was it?
No. Provided that no such charge shall exceed $3,000 in such 3-year.
In such 3-year period?
Yes.
Is there a second for the new motion to amend from Representative Farnan, seconded by Representative Iacono? Okay, is there any discussion on this item? Town Attorney Stanton Lesser.
Don't leave me
My question is it your intention that the total of such charges not exceed $3,000 in a 3-year period? Because that's not what you just said.
Yes, it is that the total of
Okay, so
such
you
charges.
need-
So would
The
you,
language needs to say that.
all right, so, I would like to withdraw my amendment. Drew, would you like to draw? Okay. That's what I do say, provided that such you want to say bill? Provided that no such charge in its aggregate shall exceed $3,000 in such 3-year period. Period.
I would say provided that the total of such charges shall not exceed $3,000 in a 3-year period.
I would accept that revision, and Betsy has properly, dutifully. You got the award, you got it. Yeah.
I just wanted, before I ask for a second, I just wanted to give you a chance to consider whether this is the motion.
Would you like to, Betsy, would you like to read it, what you have, so we can make sure, you've got a plaque, I don't have a plaque. Yeah.
I can hit you with that plaque. Keep it up. Provided that no such charge in its aggregate shall exceed $3,000 in such 3-year period.
Stan gave it thumbs up, it works for me.
Okay, is there a second to that motion? Seconded by Representative Georgiadis. Is there any discussion on the motion before the body presently? Representative Wackerman.
Through you, Mr. Moderator, I actually wanted to request 2 different people. First, Chief Liddy, if you could just explain to us what you think the average cost of one of these incidents is.
So in the past, the average simple going to a beach house, writing a ticket, and leaving 2 officers, we've been billing about $120. I think there'll be some work done on better understanding our administrative costs behind the scenes. So our thought is that may go up as far as $200. Now, in the past, I had used this on a commercial building that was a particular problem, a hookah lounge on Kings Highway that involved numerous visits by law enforcement, and the total bill that we've sent them with probably 50 calls for service there was $1,700. So I'm in support of a $3,000 cap. I don't think it would ever go over that.
Thank you. Through you, Mr. Moderator, if the town attorney could share his views on this amendment, that would be appreciated.
I don't have a problem with putting an amendment, putting a cap on the costs. But quite frankly, in reading through the ordinances, I'm sitting here, I do have some other questions that pop into my mind. For the lawyers among this group, it looks to me like you get a warning the first time, that's your 1 strike, and after that you get billed. It would seem to me that at the very least, every additional incident within the 3-year period is another charge. But does each incident then trigger the 3-year period again? And that's not clear from this ordinance. So I don't know if you want to deal with that now, or you want to, think about it, or at the next ordinance you could get billed and get another warning. So that would put the 3-year limit farther down the road. I mean, it's not really that clear from the way the ordinance is drafted, but it's just a thought.
Further discussion on the amendment, Representative Iacono.
Pamela Iacono, District 8. Mr. Moderator, through you to Attorney Lesser, just to follow up, did you mean on the amendment by adding this language that's confusing? You mean in the overall amendment, it's confusing? That language, so in other words, once we finish this amendment, is that something that you would raise as an issue that continues to be a little bit confusing?
Yes, my last comment was
Okay.
unrelated to the amendment.
Okay.
The amendment is a dollar cap, but this just is kind of a timing thing. So-
Okay.
And I think it could be addressed by every time you had a subsequent incident, you sent out another warning, and that would kind of move the 3-year period down the line again. So there's no prohibition against doing both.
Okay, while I have you up here, you can indulge me, Mr. Moderator, it's not on the amendment, but did you review, were you asked to review this?
Yes.
Okay, you just caught that now?
Yeah, as I'm sitting here reading it,
Okay,
it just popped
no, that's
in.
fine, I just wanted
Yeah.
to make sure. Okay, thank you.
Further discussion on the amendment. Representative Hurley.
Michael Hurley, RTM District 10. I'm going to reiterate my point that this piece of legislation simply is not ready. I think a lot of work has gone into it. There's a lot of questions that have come up tonight. There's a lot of differing opinions. Yes, this body is empowered to make amendments on the floor, but it doesn't mean it's the best way to do it. We just heard from the town attorney after reviewing the ordinance that he has some other concerns. So it's my hope that either the moderator sends it back to committee or the co-sponsors bring it back and say, you know what, we have a little bit more work to do, and they bring it back in a month or two. I don't see what the rush is. Thank you.
So right now, the only item before the body is that amendment. So if we take up that amendment and then there's a discussion about what to do with the ordinance, that can be taken up. But I think right now, the motion that's immediately before the body is Representative Farnan's amendment to cap the cost during the 3-year period. So we're going to take up that motion first. So Representative Farnan.
Brian Farnan, District 9. And I do believe this comment does relate to the amendment. In regards to the issue of the 3-year period, it does say subsequent to the mailing of the notice and warning and at any time during the 3-year period following the date of such notice. So it would be my interpretation as an attorney that 3-year period would span from that initial notice and warning, that first one, and then that would continue from that date for a 3-year period. And that 3-year period would not be extended or pushed back because of future issues at that property. There would be a 3-year period starting from the date of the notice and warning that would go from that date forward and would end at that 3-year period. At the end of that 3-year period, you could start a new 3-year period, and that new 3-year period would only start at the end of the first 3-year period, and it would start upon the next notice and warning that occurs outside of that 3-year period.
So is there further discussion on the amendment, the proposed amendment to the amendments from Representative Farnan? Representative Gerber.
Bill Gerber, District 2. I'm opposed to the cap, mainly because under normal circumstances, it would never be reached. But we don't know what extraordinary circumstances we may face, or the police may face, so why put it in place? It seems to make no sense to me, and it would only be limiting in extreme circumstances where there's a significant problem. Let's say major parties every week. It may not be students, it may be someone else, some bad actor that's really causing a lot of trouble, and they're there every weekend. We would surpass the 3,000. So why would we do this? It's hard for me to understand. Thanks.
Further discussion on the amendment? Seeing none, we'll go to the public for any public comment on the motion to amend the amendments to insert a $3,000 cap in the 3-year period. Is there any discussion from the public? Seeing none, we'll come back to the body for a vote. And again, the proposed amendment is to insert the language that reads as follows: provided that the total of such charges in its aggregate shall not exceed $3,000 in such 3-year period. Did I get that right, Betsy? Okay, good, thanks. All those in favor, please signify by saying aye. Oh, actually, no, we'll do a roll call vote.
Steve Chesery?
Yes.
Dave Fogel?
Yes.
Nancy Lefkowitz? Yes. Amy O'Shea? Yes. Bill Gerber?
Yes.
Aaron Lopez? Cindy Perham? Heather Dean? Alex Durrell? Sharon Pastilli? Alice Kelly? Not here. Phil Pierce?
No.
Marcy Spolier? Josh Garskoff? Joe Siebert? Ruth Smay? Jay Wolk? Steve Barretts? Hannah Gale? Lisa Havey? Lauren Bove? Mark McDermott? Jill Vergara? Karen Wackerman? Carrie Burcham? Pam Iacono? Christine Messina? Pete Tellman? Brian Farnan? Drew Georgiadis? Margaret Horton? Sam Cargill? Michael Hurley? Eric Sunman? Motion passes 17 yes, 14 no, 2 abstentions.
So that motion carries, 17 yes, 14 no, 2 abstentions. Okay, so now is there any further discussion on the proposed amendments to the ordinance as amended? Representative Georgiadis.
Drew Georgiadis, District 9. Through you, Mr. Moderator, I ask that you invite Chuck Abercrombie, the president of the Fairfield Beach Residents Association, up to address some of the issues of this amendment. He's well versed in the amendment, the amendments to the ordinance, and he might be able to address, I know he can address some of the issues that were raised by Attorney Lesser.
Well, Attorney Abercrombie can comment during public comment. If there's a question that you want to ask him as someone that was involved in developing the ordinance, I'll accept that.
Okay, I'd like to ask through you to have Mr. Abercrombie address the issue raised by Attorney Lesser that the 3-year period keeps getting pushed back with every subsequent violation.
Okay, Mr. Abercrombie, can you address the question raised by the town attorney on the clarity of the ordinance as he stated it?
I think I can. The ordinance provides for essentially a 2-step process. The first is that upon the police responding to a location where there is a violation, they issue a notice and warning. And the ordinance says that after that, the date of that notice and warning, and at any time during a 3-year period following the date of that notice and warning, there is a second event where a person on the property or near the property or arising from the property is found guilty of one of the sections that are criminal sections that are cited in the statute, or that they're given one of the 2 different types of dispositions, that would trigger the ordinance and would then cause the bill to be issued for those 2 visits. However, with respect to what happens after that, we go back to the beginning in subdivision A3 where it says, and at any time during the 3-year period following the date of such notice and warning. So the 3-year period is timed from the date of the notice and warning. So it's not renewed or extended. It begins with that notice and warning and carries for 3 years, at which time it terminates. And if there are subsequent incidents, after the second one, there can be a bill, but it would not go beyond a 3-year period, which is what this ordinance says in section A3. Hopefully that clarifies.
Thank you.
Thank you, Mr. Moderator.
Is there further discussion on the ordinance? Representative Iacono.
Pamela Iacono, District 8. Through you, Mr. Moderator, I think to the Town Attorney, what's the appeals process on this? I don't see it written in the ordinance.
I think really the only appeal would come on something like this when you went to collect it, if it didn't get paid. You'd have to sue the person, and they could raise defenses and try to fight it there. That's the only appeal that I can see provided in this. This is something it's really kind of definite. You get a warning, and then someone gets arrested and the case gets nollied. I mean, I don't know that there would be an appeal from that. It's really more of a fact. It's not much of a subjective situation. But then you would wind up in court, I think, ultimately, if the person didn't pay. So
But you
they
just
could raise
would go to
defenses there.
small claims court on that.
What? Probably, yeah.
Is that something that should be outlined in here? I mean, should there be, most of our
It's
ordinances.
not a
have-
citations, so you don't really need a citation procedure. And there's no provision for it in this. I think it's okay the way it is. And if the person really wants to, if the town actually winds up suing somebody over this and they want to contest it, they can come in there and contest it.
Gotcha, thank you.
Further discussion on the ordinance? Representative Hurley?
Michael Hurley, RTM District 10. I'm going to vote no. I don't think this ordinance is anywhere near ready. I had a grave number of concerns coming in here. I've been on the body close for 10 years. I've seen a lot of ordinances come and go, and I know a lot of hard work went in it, but just the way the ordinance is written and structured, it's very, very cumbersome. So for the last and my final time, I will implore the moderator to do the right thing and to send it back to committee and, make an appeal to the co-sponsors, just to take a little bit more time. Let's get it right. No need to rush it. Thank you.
So I'm not going to do that, but I will invite the town attorney to come up and to just advise us whether, in light of the continued discussion, whether he thinks that it should go back to LNA for a further form review, or whether we can act on it tonight.
I don't think it really needs to go back, quite frankly. I think that Representative Farnan and Mr. Abercrombie's interpretation are certainly reasonable interpretations of the ordinance. Basically, the way I see it, if you take that interpretation, you get a freebie every 3 years, basically. So at the end of 3 years, you start with the warning process again, and then you go forward. So, and I think that's a reasonable interpretation. I don't know that you'd really do much improvement on the ordinance if you sent it back.
Is there further discussion on the proposed amendment to the ordinance? Representative Iacono.
Pamela Iacono, District 2. I too am going to vote no on this for the simple fact that it is, regardless of whether or not we're going to send it back to LNA or not, it's too confusing for somebody, a layman, to understand. And I think the fact that it took 3 attorneys to determine a certain section of language of what it was is not really something that we would be something that we should be putting forward at this time. It's not the substance so much. I do think it is the form. I understand the ruling not to send it back. I don't have an issue with that. I just personally don't think it's ready and it needs more massaging. That's my first concern. I think, unfortunately, I think we moved it out of LNA too quickly. That's one of my reasons for voting no. My second concern is one that was raised at committee and one that I commend Representative Vergara for raising, because I share the same feeling, and that is that I'm concerned now, and Selectman Bateson touched upon it, that there's going to be certain selectivity in choosing renters. And because you are going to be penalized, you're moving into a house and with the house has a strike on it, to use Selectman Bateson's words. So I am worried about how landlords are going to choose their tenants and whether that has the potential to become discriminatory. And that's bothersome to me. The 3-year time period, I understand it from an administration standpoint with the police department, but we ought to work to make that faster, and it should be less than 3 years. So I can't support this ordinance the way it is. I wholeheartedly do support our police department. You know, it was the Fairfield Buttes Association that approached the police department with this, not the other way around. And I just think we have some more work to do on this. If there are the votes to pass this tonight, I'm hoping that maybe some people will think about looking at the sections that don't make a whole lot of sense or provide a lot of clarity, and that there is another discussion about the length of time on this. I just worry that I don't know that this is going to solve the problem that they're looking to solve. Thank you.
Further discussion, Representative Georgiadis.
Drew Georgiadis, District 9. I'm going to be voting yes for this. There's been a lot of time, a lot of energy put into it, especially by our police chief, Chief Liddy, and by Chuck Abercrombie, and all the people that are sponsoring it. I regret that Representative Iacono doesn't think that enough time was spent, and I'm sorry that she couldn't make it to the special LNA meeting that was called on a Tuesday night to discuss this. We must have spent at least 2.5 hours, 3 hours going over the ordinance and working on all the details. And a lot of people in LNA worked very hard that night and have made extra time. So I want to thank the people that did work and spent the time. And again, these are amendments to an existing ordinance. Some of the language that, you know, isn't even up for discussion tonight. This is a discussion on the amendments to update an existing ordinance, and I'm going to vote yes. Thank you.
Further discussion, Representative Fogel.
David Fogel, District 1. I have a few concerns about the proposed amendment. 4 actually. Number 1, the 3-year period. We already discussed that, but just for the record, I support a 2-year period. I think 3 years is too long. That's concern number 1. Number 2, and this hasn't really been discussed, is the open-ended nature of the language of the costs that can be recovered under this ordinance. Now, we capped it with the amendment at $3,000, which I support, but I still have concerns about it. If you look at the ordinance, it talks about the reasonable cost of police response, notice and warning processing, arrest, processing, court-related costs, and any related costs incurred by the town. Now, the chief talked about an estimate for the police response and maybe some of these items, but I'm not sure his estimate included all of these items. And for example, the last one, any related costs incurred by the town, to me that seems very open-ended. I mean, start thinking of examples. The police arrive, maybe there's an accident, a car accident, and maybe it's the people who are causing the disruption who caused the accident, maybe it's the police fault. But either way, there's cost involved. Does that mean that is going to also be included and charged to the homeowner? I don't know, but that's just one example I thought of 5 minutes ago. I'm sure there are plenty of others. So I don't like the open-ended nature of the language. Similar point is, I don't know, frankly, because I'm relatively new, but is there a precedent ordinance where the remedy is cost recovery as opposed to a specific fine or penalty? That's one of my main concerns here. I mean, I'm not questioning that this ordinance should be in place, and if people are disrupting, that there should be a penalty. But why not try to come up with a specific amount and then debate that? But this language to me is too open-ended. Similarly, my third point, and I'll try to be quick, is to Representative Iacono's inquiry about an appeal process. It seems to me that it would be important to have some kind of appeal process, and particularly because the language is so open-ended. And so in response to the town attorney's point, to me it's even more important that there be an appeal process outlined to be able to appeal the reasonableness of the charge. Otherwise, you have no recourse as a homeowner, and that doesn't seem right to me. My final point, which I don't think has been addressed either, is the fact that costs can be recovered even when the charges are dropped. Now, unless I'm misunderstanding the language, I was a lawyer for only 2 years, not very long, but that doesn't seem right to me either. I mean, again, even if the charges are dropped up to $3,000, that doesn't seem right to me. Thank you.
Further discussion? Town Attorney Lesser? Yeah.
I just want to respond to the issue of the reasonableness of the charges. And if you look at the ordinance, it talks about the fact that the charge is a debt. It's collectible by the town in the manner as case of an obligation under a contract. So again, as I said before, you'd have to sue the guy. If we sue somebody, it's our burden of proof. I have to prove the case. So I have to prove that all these charges do fall under the statute. And at that point, or under the ordinance, at that point, I think the owner would be able to say, hey, this doesn't fall, and then it would be up to the judge to decide whether it was a proper charge or not.
Further discussion? Selectman Bateson.
Thank you. Ed Bates at North Street. I was on board half an hour ago. Now I'm frightened. As a landlord, now you've brought up, Representative Fogel brought up a couple good points that, that last clause in there, the open-end nature of it, that does cause me concern. I've been down there, done ride-alongs with the police department. I see the resources we have down there, and quite frankly, that's the only frame of reference I was thinking about. Like if something happened at my house, that I would be responsible for the police showing up. I hear this last clause, any other related costs, now my fur goes up. Now I have no control. I have a general idea of what a police car costs, what a patrolman costs, and so forth. So now I'm concerned about that, and also to the appeals process. I'd like to trust Chief Liddy in saying that, yeah, well, a reasonable cost is $200. It's government. Things happen. I might get a bill for $1,000. If I'm upset about that, where do I go? It's a bill for $1,000. If I think that these or the costs are outrageous, who do I appeal it to? I just think that if we're instituting a fine or a penalty, you should have a right to an appeal somewhere too. So at this time, maybe a little bit more work.
Further discussion? Representative Horton?
Margaret Horton, District 9. I am voting yes on this, as you can presume, being one of the co-sponsors. I think it's important to remember that these amendments to the ordinance are not about the penalties themselves that are assessed. It's simply about how the town can recover the costs. And the penalties are only assessed in very specific dispositions, which are outlined. Also to the idea, talking about it being onerous for landlords, and obviously that is something that we want to be very mindful of, but I think we need to keep in mind that this really developed because, particularly in the beach area, we have a situation where we have landlords who are not at all paying attention to what's happening at their properties, and we want to, bring this on to help them be more accountable for what is going on. That it's not a question of, we're not trying to be more onerous, it's really about making landlords more accountable.
Further discussion? Representative Iacono?
Mr. Moderator, through you to Chief Liddy, we heard public comment, or there was public comment at committees regarding that this was the worst beach year ever. 17-18 was the worst beach year ever. Chief Liddy, is that, are there, you did not make that statement, a member of the public did. Is that true? Are the instances of trouble up at the beach, was that the worst beach year we've ever had?
Chief Liddy?
No, I don't have the statistics to show that at the moment, but having lived through 30-some-odd beach years, this was not the worst that we've ever had. Maybe a little different. We've moved the problem out of Lantern Point to other areas of Fairfield Beach Road, but every year is a little bit different, but I would not call this the worst.
Thank you.
Further discussion from our members? Seeing none, we'll see if there's any public comment. Does anyone from the public wish to speak to the item? Please come forward.
I'm Charles Abercrombie. I live at 251 Penfield Road, and I'd like to address some of the misstatements that have just been made by various members of this body. First, it was not the Fairfield Beach Residents Association that originated these amendments. It was derived from the work of the Beach Advisory Group, which is comprised of the first selectman, the chief of police, first Chief McNamara, and then Chief Liddy, 2 representatives from the university, and 2 representatives from the neighborhood. So that's where this all started. Second, there's been comment about whether this is perfectly clear, and I believe it is in the sense that the ordinance lays out in a step-by-step process as to what needs to occur before any charge is imposed on a homeowner. With respect to the charges or the types of charges, it's very clear, and it states in the section that a bill itemizing the charges shall be provided to the property owner. The next point is that it is not about the tenants who live in these properties. It is about the safety and security and peace of the neighboring houses and the people who are affected by disrupted places. There was a comment with respect to whether if charges are dropped, that someone could be a homeowner could still be charged. That is simply not true. The statute or the ordinance is very clear that it refers to a person being found guilty of 1 or more sections of the criminal code, or in the event that the case is nollied or a grant of accelerated rehabilitation is given, neither of those charges or neither of those dispositions are determinations on the merits of a case. So it's a way of giving an offender a break, even though that person may have actually committed the offense that they're charged with. With respect to the appeal issue, it's very clear that once a person receives an itemized bill, if they have a problem with it, obviously there's access to the police department. But in the absence of satisfaction, the homeowner simply can decide not to pay and leave it, as the town attorney pointed out, to the town to carry the burden of showing that the charges were proper. So there is an effect, without stating it explicitly, an appeal process that's available. And a person who receives an itemized bill would have an opportunity to understand exactly what it is they're being charged with. So with respect to all of that, I think this is in fact a clear ordinance. And my final point is, it has never been said at committee by me or by anyone else that the 2017 or 2018 school year was the worst ever at the beach. Because believe me, it's much worse. It was much worse in earlier years. And I can personally attest to that. And in fact, I would refer you to the memorandum that was submitted in support of this.
Mr. Abercrombie, can you speak into the mic a little more directly?
Where it says, that after a very difficult September 17th to May 18th school year, the Beach Advisory Group was formed, and these amendments resulted therefrom. It was never said that this was the worst year on record, and I believe that the chief would concur with the phrase that this was a very, or that was rather, a very difficult year. So for all these reasons, and for the benefit of the residents who live in this town, this ordinance should be passed, or the amendments should be passed. Thank you.
Is there any further comment from the public? Seeing none, we'll come back to the RTM for comment. Representative Hurley.
Michael Hurley, RTM, District 10, and thank you, Mr. Abercrombie. That was quite helpful. I didn't have all of that background. I believe you said that the first selectman was part of the group that developed the amendments to the ordinance. And if that's correct, through you, Moderator Pierce, to the first selectman, I would just like to get his thoughts on the amendments and the discussion here tonight. I know we've had some really terrific conversations of late about ordinances and the importance of everybody understanding the ordinance and educating departments and the public about them. So if I heard Mr. Abercrombie correct, that you were part of the group, I'd appreciate to hear your thoughts on the ordinance. If I misheard him, then I guess I don't need to hear that, and maybe then it would go through you, Mr. Moderator, back to Mr. Abercrombie, and then he could clarify.
First Selectman Tetreault.
Thank you. To clarify, what Mr. Abercrombie was referring to is there is a beach advisory group. We meet every month to talk about the issues in the beach areas. So if there's a question of both the import of this, the ongoing issues, and the importance to the neighborhood, we have put in quite a bit of time and effort on doing that. There are a number of issues we talk about. We talk about with Fairfield University and their representatives, different programs. We've set up some joint committees of residents and students to kind of look at this so we can get buy-in from both sides to help address the fact that we have students living in a residential neighborhood and trying to get understanding on both sides, that students in some cases need to be students, but they also need to realize that it's a residential neighborhood with families that are part of what they have agreed to live in. There are a number of issues that came up in that group. This was one, looking at the cost recovery mechanism was certainly one of the recommendations that came out of this group, but I was not specifically involved in looking at the wording, doing the research, looking at other communities, which was part of the work that was done. I think Mr. Abercrombie played a big role in doing a lot of that firsthand research and coming up with the proposals that went into this ordinance.
Okay, well, thank you for clarifying.
Further discussion from the RTM members? Seeing none. Oh, Representative Fogel.
David Fogel, District 1. Just one point. First of all, I appreciate Mr. Abercrombie's comments, and that was helpful. And I am very concerned about the disruption in the area, but I'm also concerned about the rights of homeowners and property owners. So I'm going to zero in on one issue, and this is, I guess, a point of inquiry for the town attorney about a point I raised earlier, and he responded to, Mr. Abercrombie. What exactly does it mean, the term "knolled"? Because my understanding is that could mean charges are dismissed, and I agree that that doesn't necessarily mean that the person didn't do it, but it also doesn't mean that the person did do it. And so therefore, I'm concerned about the implications of it. So can you explain that term?
So now the term nolli is short for nolli prosequi, which is a Latin term, which basically means that the state is not proceeding with the charges. They're basically dropping the charges. Technically, a nolli is not, the case is not erased from your record for 13 months. It's not a dismissal, which gets erased immediately. It'll stay there for 13 months. In 42 years, I've never seen a Nolly reopen, although the state does have the right to do it. They're dropping the charges, is basically what it is.
So if I may just make the point, I guess my concern would be that someone could end up being responsible, a homeowner, responsible for paying up to $3,000 for charges when it has not been adjudicated, it has not been determined that they or their tenants were at fault, and that would be my concern.
Further comments? Attorney Lesser?
No one has really talked about this, but as far as the landlord being responsible, it's my opinion that probably no landlord will ultimately be responsible, because all the smart landlords will put a provision in their lease that any violation of this ordinance will result in the charges being added to the rent and paid by the tenants. So as a matter of fact, it does give the town a little bit extra control, because if the smart landlords will pass these costs on to the kids, and so I think it does give a little bit more control. I mean, I would certainly recommend to any client that came to me that had a tenant to put that provision in the lease that if there are charges that are imposed by the town, they have to pay them as additional rent. So.
Further discussion? Selectman Bateson.
Ed Bateson, North Street. To the town attorney's point, you're right. Most leases do have provisions in there that would cover the expense of something like that, and I do have those in mind. But just so the body knows, I wouldn't be so dismissive at passing along a cost to my tenant that hasn't been adjudicated or heard. I mean, yes, I have the power to do so in my lease, but we all want to sleep at night. I don't want to pass a bill on just because, the charges were dropped, and here I am in this legal process with a potential bill. I'm passing it on to my tenant, but quite frankly, I could get challenged on that. It was never heard. So, we're getting into, not so clear waters here. I get where we're going, but we really need to think about this a little more.
Further discussion? Representative Pastilli?
Mr. Moderator, through you, I'd like to ask Mr. Tetro or Mr. Bateson a question, and that is, what's a typical rent of a two-bedroom apartment at the beach?
I have no idea.
Selectman Bateson?
Yeah, they vary anywhere.
Back of envelope.
For a school year, it depends upon, I'd say 10,000 a bedroom. That's what I would say is a
So
general.
$10,000 a bedroom per year, and we're talking about an average of $130 a call. So as a percentage of the overall rent, we're talking about a very small bill.
But you're talking about a principal.
Further discussion? Seeing none, we'll take a roll call vote on the amendments.
Steve Chesery? No. David Fogel? No. Nancy Lefkowitz? Yes. Amy O'Shea? No. Bill Gerber?
Yes.
Aaron Lopez? Cindy Perham? Yes. Heather Dean? Yes. Alex Durrell? Yes. Sharon Pastilli? Yes. Phil Pierce?
Yes.
Marcy Spolier? Yes. Josh Garskoff?
Yes.
Joe Siebert?
Yes.
Ruth Smay?
Yes.
Jay Wolk?
Yes.
Matt Ambrose?
No.
Steve Barretts?
Yes.
Hannah Gale? Yes. Lisa Havey? Yes. Lauren Bovee? I hear her coming.
Lauren Bovee?
Mark McDermott? Jill Vergara? Karen Wackerman? Carrie Burcham? Pam Iacono? Christine Messina? Peter Tolman? Brian Farnan? Drew Georgiadis? Margaret Horton? Sam Cargill? Michael Hurley? Eric Simon? And who was not here? Aaron? Thanks.
So the proposed amendments to the ordinance passed 23 to 10 to 1 abstention. So the motion to amend the ordinance passes. Item 7, to consider and act upon amendments to the tax relief for the elderly and disabled homeowners ordinance, section 95-7 to 97-15.4 of chapter 95, article 3 of the town code of the town of Fairfield, sponsored by the Senior and Disabled Tax Relief Committee, Cynthia Parham, District 2, Mark McDermott, District 7, Jill Vergara, District 7, Peter Tallman, District 8, and Michael Hurley, District 10. Is there a motion to discuss? Moved by Representative Vergara, seconded by Representative Wackerman. Is there any discussion on this item? Representative Vergara.
Jill Vergara, District 7. Because the Board of Finance has failed to act for yet another month, I'll have to make another motion to postpone this item till the next meeting, which is, I believe, April 29th.
So there's a motion to postpone the item to April 29th. Is there a second to the motion? Seconded by Representative Dean. Is there any, is it the 29th? So let's make sure we have the right date for the motion. It is the 29th. Is there any discussion on the motion to postpone? Representative Hurley?
Hi. Michael Hurley, RTM, District 10. I think there's a lot of blame to go around this senior tax relief. And I heard Representative Vergara blaming the Board of Finance when I spoke at the last meeting about how I thought a reasonable approach should be taken. I don't think I need to go through that again. But I think, one of the reasons where we are where we are is we have a state statute in place. And senior tax and disabled relief has been amended a few times over recent years. And as part of those amendments, and I'm not trying to take a cheap shot at the town attorney, but part of his responsibility is to make sure that those amendments are consistent with federal and state law. Now, that didn't happen. So, if Representative Vergara is going to place blame on the Board of Finance, I don't think that's fair. I think there's a lot of people where blame should be passed. Thank you.
Further discussion on the motion to postpone. Representative Vergara.
Jill Vergara, District 7. All I'm asking for is an established process from the Board of Finance, and we've gotten no communication from them. So that's what we're asking for, and I'd like them to it's an easy enough request to make a decision on this up or down. If they don't want this proposal to go through, they can reject it.
Further discussion on the motion to postpone. Representative Iacono.
Pamela Iacono, District 8. There is a very simple process to make that happen. You call for a vote, and you send it to the Board of Finance. That's how that happens. Number one. Number two, yesterday, there was a meeting with Chairman Flynn, Representative Vergara, and Representative Wackerman. So to say that there's been no communication on this issue is false.
Further discussion on the motion to postpone. Representative Wackerman.
Karen Wackerman, District 7. We did have an informal discussion yesterday with Chairman Flynn, but the Board of Finance it's their job to recommend to the RTM an ordinance about senior tax relief. Our committee worked so hard the last several months and proposed a very thoughtful ordinance and have asked the RTM to recommend it, and there's just radio silence from, the Board of Finance to recommend it, and there's just radio silence from them as a board. It's in their lap. They can take a look at this now and they can do something about it. I also want to defend Mr. Lesser. This hasn't been, the state statute wasn't really being honored for maybe 30 years, and I don't think Stanton was the town attorney for that whole time. So this is water under the bridge in terms of what happened, but right now we have a really good ordinance or changes to the ordinance that's been proposed, and the Board of Finance can look at that and say, we don't like this part, we're not going to recommend it, something, and they haven't done that. So we're waiting to see that.
Further discussion. Representative Iacono.
With all due respect to my colleagues, and I mean that sincerely, because the last thing I wanted to do was get up and get into this political hotbed on this. They cannot take action on something we have not referred to them. This RTM has not voted anything out to send to them to recommend. So this has become a big, giant process football that I go back to my original statement 2 meetings ago, which is my recommendation is to withdraw this, and it's my personal interpretation based on the statute that this lies within the RTM. Within the Board of Finance. The statute says upon recommendation of the Board of Finance. If the Tax Relief Committee wants to vote on the motion that's on the table, then we should vote on the motion with an amendment to send it to the Board of Finance for a recommendation. And that would get the ball rolling. But if that's not the case, for all intents and purposes, from a process standpoint, this is dead. It was ruled on by the town attorney that the whole thing lies with the Board of Finance. And it's a process problem at this point, folks. That's it. So I just want to see this get resolved for the sake of this body, the sake of the seniors and the disabled who are looking to us to make a decision. And I implore this back and forth ping pong to stop. Somebody make a process call, please.
Further discussion. Representative Wackerman.
Karen Wackerman, District 7. Through you, Mr. Moderator, I'm wondering if our town attorney can comment on the question raised by Representative Iacono, which is whether the RTM has to first vote on the changes before it can go to the Board of Finance.
The answer to your specific question is no. The RTM doesn't have to vote on anything, but anybody can call up the chairman of the Board of Finance and say, hey, why don't you do something? But it's got to come from them. So you can make any recommendation you want. Anybody can. They can accept it or reject it. But ultimately, the recommendation has to come from them, and if they're not willing to act, then you can't do anything.
I guess my question is whether we have to formally do anything to present it. I know that that Representative Vergara already did present it to them. There's nothing
I
else?
don't think that would trigger anything that they would have to do. They certainly know that there are proposals out there. If they want to act on them, they can.
Mm-hmm.
I think any one of the Board of Finance members could propose something at a meeting, and say, why don't we act on this? And then that would get the ball rolling. And you certainly can have a motion. There's nothing to prohibit you from doing it, but I don't think that the Board of Finance would have to listen to you, quite frankly.
Okay, so I guess just for my 2 cents, I hope that they take it up and do something because the seniors in town need some relief.
Further discussion on the motion to postpone? Representative Vergara.
Jill Vergara, District 7. I wanted to clarify that process issue. Like I said the last time, we encountered this situation in the 80s once before. It's not like we're reinventing the wheel here. We had a situation where an RTM had a proposal before it from a senior tax relief committee, and they realized that the Board of Finance hadn't made a recommendation as the statute requires. So they sent it to the Board of Finance to make that recommendation. That's what we're asking them to do right now.
Further discussion? Representative Hurley.
Michael Hurley, RTM District 10, and I think everyone knows I'm a member of the committee, and I'm going to repeat what I said last meeting. I think the biggest challenge here is that, number one, whether we like it or not, and I think the town attorney was very clear that the power is vested with the Board of Finance, but the Board of Finance cannot enact an ordinance on its own. We're the body that enacts the ordinance. So in some ways, to me, it's very similar to RTM redistricting, where we had a binding ordinance that came out of committee that we couldn't make amendments to. That was a little bit easier because it was one body. I think the challenge here is that you have the Board of Finance and you have the RTM. You have two different bodies. That's why last meeting I recommended, and I'll make that recommendation again, that I think there should be a joint meeting of the leadership. It could perhaps be a meeting of SLMC that Karen Wackerman could, call, and she could invite the leadership of BOF, of the Board of Finance, Tom Flynn and Jim Brown, and we could, perhaps do some sort of, I don't know what legally we could do, but some sort of sense of the leadership, sense of the body, something or other, which would sort of just lay out some sort of outlines as to how we think we would address this going forward, so that there's at least some clarity, because I think that's the frustration here. I think that's the frustration I'm hearing from Representative Vergara, Representative Wackerman, Representative Iacono, and myself. I think everyone wants to do what's best for the seniors, and a ton of work was put into this ordinance. And I'll tell you, if we don't have some coming together procedurally of the minds, I just don't see senior tax relief, getting done. And I think that would be a real shame, for our seniors. I don't claim to sort of know exactly how to, go about doing that, but I think there needs to be some sort of public meeting discussion about that. So I hope that made some degree of sense.
Further discussion on the motion to postpone? Representative Vergara.
I'm willing to work with the Board of Finance, but a large part of my frustration is their unwillingness to address this in a timely way.
Further discussion on the motion to postpone? Seeing none, is there anyone from the public who wishes to comment on the motion before the body? Seeing none, we'll come back to the RTM for a vote. All those in favor of the motion to postpone, please signify by saying aye. Aye. All opposed? Any abstentions? Hurley, Representative Hurley, Iacono, Farnan, Tallman, Messina, O'Shea, I wrote it down, Fogel, Cesare, how do I really say it? Chessari. Okay. Somebody else said Chessari. Durrell, Cargill, Sunman. Like everybody? Okay. So those are the abstentions. So 23 yes, 0 opposed, 11 abstentions, so the motion to postpone carries. Next is item 8. The moderator has referred a reusable checkout bag ordinance sponsored by Nancy Lefkowitz, District 1, Eric Newman, District 2, Heather Dean, District 3, Matt Jacobs, District 3, Sharon Basili, District 3, Phil Pierce, District 4, Jay Walk, District 5, Lisa Habey, District 6, Lauren Bove, District 7, Mark McDermott, District 7, Jill Vergara, District 7, Carrie Bertram, District 8, Drew Georgiadis, District 9, and Sam Cargill, District 10, to the Legislation and Administration Committee under Rule 32 of the RTM Rules to Regulate. LNA voted that out of committee to send it to the RTM, so it will come before us in April, and it will be voted on at our regular May meeting. Item 9, to consider and act upon any other matters presented to said meeting in which may be properly acted upon under the rules of the RTM. Is there any discussion on this item? Seeing none, I do want to alert our members that the town budget books are available at the library, so please pick up your budget book when you have a chance. If there's no further discussion, I'll entertain a motion to adjourn. Moved by everyone, seconded by everyone. We'll adjourn.